Good evening, guys. Good evening, and welcome to Gradeup. I, Sarthak Sharma, welcome you all to this wonderful platform that makes your learning easy, effective, efficient, and at the same time interesting. Good evening, guys. Today is part three of this legal reasoning question session, wherein we will discuss 10 legal reasoning questions for your AILET and MH-CET preparation. Yes, AILET and MH-CET में principal fact question आते हैं. You all know it. So we will discuss some more principal fact questions and let's see what's your score today. Yesterday, a lot of students scored a perfect 10 score, 100% score, and it's your target for today as well. Hi, good evening, Trisha. Hey, Prakash. Hi, Shifa. Hey, Divya. Good evening, Vidhi. Good evening, Bhavna. Good evening, Mukta. I hope you all are fine. You all are well. Let's start with the session, guys. Let's start. But before proceeding, what is the date today? क्या डेट है आज? Today is 13th, 13th of July, and today we celebrate globally World Youth Skill Day. Yes, skill is something that can either make you, break you. Yes, a bad skill can break you, and a good skill can make you. Skill is something that can either break you or make you. And today is World Youth Skill Day, and Gradeup is celebrating this day with a wonderful offer on the theme of World Skill Day that starts today. The sale starts today, and today is the first day of World Youth Skill Day, wherein Gradeup is providing you a flat 50% discount on Gradeup Super for CLAT, SLAT, AILET, MH-CET, and all other law entrance examination. You can enroll to Gradeup Super with a flat 50% discount. Just use the code SKILL50. काबिल बनने की तैयारी, काबिल बनने की सही तैयारी आपके घर से है जारी ग्रेडअप के साथ. So let's start, guys. So you may enroll for Gradeup Super. It's a now or never offer, so avail it as soon as possible. Then, guys, an English language and critical reasoning booster special course. It's a special course that is specifically devoted to this section, the English language and critical reasoning. Do you know why? Because these can be the most scoring sections of CLAT, but unfortunately, a lot of students loses most of the marks in these sections. A very less understanding, a minimal understanding, थोड़ी सी understanding से ही आप इन sections में wonders कर सकते हैं. So to make this section the game changer for all of you, Gradeup had come up with this special course. There are 90 plus live classes, 1000 plus mocks, 80 plus 1000 plus practice tests, 80 plus mocks, and 150 plus sectional tests. Enrollment have started for this course. You may enroll for it. And then, guys, why you should take this course? If this question is coming to your mind, then read these points closely. This course has a duration of 10 months. In 10 months, you will be an expert of the English language and CR section of CLAT. From scratch to shine. From scratch, you will shine after 10 months in this section. So, guys, you should take this course because of the following reasons, because of these reasons. And now, let's start with the present session. Question number 1 on your screen. It's an assertion reason question. Hi, good evening, Siddharth. Good evening, Poonam. Let's start with the session. Assertion and reason. Question number 1 on your screen. Let's see how many of you answered correctly. And although it is something which is discretionary, I would just suggest you to tell me your score in the live chats or in the comment section after the end of this session. Okay, I have started getting answers. Samaira is saying C. Aslam is saying A. Let's wait for some more answers, then I will tell you that what is the right answer. Prakash, Naman, Ridhi, everyone is saying A. Most of you are saying A. Let's see, guys. No, C is the right answer. A is not the right answer. C is the right answer, guys. Fundamental rights को ध्यान से पढ़िए. Everybody is equal in the eyes of law. Yes, that is true. Article 14. I admit it. So A is true. But law provides equal opportunities to all. Is it true? Article 15. Do not it had exceptions in clause 4, clause 5, clause 3? that provides reservation for women, that provides reservation for backward classes, OBCs, SCs and STs, that provides reservation for EWS category as well after the recent 103rd amendment. So guys, R is not true. Law provides equal opportunity to all? No. Law provides, you can say law provides equal opportunity to equals, but not to all. There are reservation and that is called affirmative action. That is positive discrimination. Affirmative action. Got it? That's why C is the right answer. Equal should be treated equally and unequal should be treated unequally. That is the right to equality in Indian Constitution. Because we have affirmative action. That is positive discrimination. Or you may say reverse discrimination. So the right answer was C. I hope you got it that why C is the right answer. A lot of students answered it wrongly, guys. Although it was an easy question. Not an easy, but it was a mediocre question, not a hard one. Got it? Yes, Shivam, law treats everyone equally. चाहे वो एक प्राइम मिनिस्टर मर्डर करे या पियोन मर्डर करे, दोनों को सेक्शन 302 ऑफ आईपीसी के अंडर ही सजा मिलेगी. So law treats everyone equally, but there is no equal opportunity for all. For deprived sections of the society, whether they are whether they are deprived on the basis of gender, like women and children, or on the basis of classes, backward classes, OBCs, SCs, they have reservation. So क्या मतलब आपकी लास्ट स्टेटमेंट का? नमन, अ स्टूडेंट वाज आस्किंग मी कि क्या सर लॉ सबको इक्वली ट्रीट करता है? तो यस, करता है. Now, question number 2 on your screen. False imprisonment. I hope you know it what it is. Aditya, I know president is immune from any criminal trial. He is immune from any criminal liability. But मैंने प्राइम मिनिस्टर बोला था, प्राइम प्रेसिडेंट नहीं. Yes, guys, you all are right. The right answer is A. He was not falsely imprisoned by the mob because there was not an absolute restraint over his liberty. Yes. False imprisonment includes absolute restraint. Absolute restraint. Which means आप एक particular boundary के अंदर confine हो गए हैं. You have been confined to a particular boundary. That boundary can be physical as well as mental. अगर आपको इस रूम में कोई बंद करके दरवाजा खोल दे बट कहे कि अगर बाहर निकलोगे then I will shoot you. Then due to fear you will not get out of this room. Then also you are falsely imprisoned. You are wrongfully confined. False imprisonment in criminal law is called wrongful confinement, and in tort law it is called as false imprisonment. Wrongful confinement. And partial restraint जब होता है तब उसे कहते हैं wrongful restraint. Okay, which is an another wrong under tort law as well as in criminal law. Wrongful restraint. So here P के अगेंस्ट मॉब ने wrongful restraint किया है, wrongful confinement नहीं, means false imprisonment नहीं. So P was not falsely imprisoned. P was wrongfully restrained. So the right answer is A. Question number 3. Article 21. What can be the right answer to this question? You have to decide like a judge. What can be the right answer? Come on, guys, it's an easy question. Riddhi is saying A. Let's wait for some more answers, Riddhi, then I will reveal the right answer. Everyone is saying A. Was it an arbitrary act? Are you serious? Because Supreme Court has a power to award death penalty. A is not the right answer, B is the right answer. It was a lawful killing, not in violation of Article 21 of the Constitution. Article 21 says that no one shall be deprived of his life except the procedure established by law. The decision of the Supreme Court is according to the procedure established by law. Procedure established by law हमने कहां से borrow किया है? We have borrowed it from Japan. So guys, although he was a terrorist, Article 21 is available to persons. Persons include citizens as well as non-citizens, means terrorists or foreigners as well. So here, Supreme Court awarded him death sentence. It is according to the procedure established by law. Although उसको प्रेसिडेंट के पास मर्सी के लिए नहीं जाने दिया, that is something different. बट उसको जो डेथ पेनल्टी अवॉर्ड हुई वो अकॉर्डिंग टू द प्रोसीजर एस्टेब्लिश्ड बाय लॉ थी. दैट्स व्हाई बी इज द राइट आंसर. आदित्य, मर्सी पिटिशन इज अ प्रोसीजर एस्टेब्लिश्ड बाय लॉ, बट अगर मर्सी पिटिशन के लिए किसी को नहीं भी जाने दिया है, देन ऑल्सो इट कैन नॉट बी कॉल्ड एज एन एक्स्ट्रा जुडिशियल किलिंग. गॉट इट? It was not an extrajudicial killing. This death penalty was in accordance to the procedure established by law. So it was not an arbitrary act. And it was not in violation of Article 21. Death penalty is unconstitutional. The statement is wrong. The only visible right answer is B. क्या डाउट है आपका हरितांश? प्लीज रिपीट योर डाउट. मुझे आपका डाउट नजर नहीं आ रहा. अपना डाउट दोबारा से टाइप कीजिए. ये डाउट नहीं आ रहा है मेरे पास. सुप्रीम कोर्ट ने जाने से मना नहीं किया है. जरूरी नहीं है कि प्रेसिडेंट के पास जाने ही दिया जाए. सुप्रीम कोर्ट हैज अ पावर टू अवॉर्ड डेथ सेंटेंस. उन्होंने कर दिया. बट दिस थिंग इज फ्रॉम आर्टिकल 21. रिधि, अगर आर्टिकल 21 स्पेसिफिकली नहीं भी लिखा है तो नो वन शैल बी डिप्राइव्ड ऑफ हिज लाइफ. इट इज रिटन इन आर्टिकल 21. सो द प्रिंसिपल इज टेकन फ्रॉम आर्टिकल 21. Question number 4 on our screen. Okay. This principle is from General Defenses under Tort Law. Okay, what can be the right answer? Zarun sued Kashyap for damages. प्रिंसिपल समझ में नहीं आया ऋषिका. General Defenses in Tort Law. This principle is from General Defenses in Tort Law. All of you are saying B. Guys, B is the right answer. A tortious suit cannot be filed if the plaintiff himself is the wrongdoer. And it is a general defense in tort law known as plaintiff the wrongdoer. जहां पे plaintiff खुद गलत है. This principle in other words can also be written as he who comes to seek justice should come with clean hands. ये principle भी काफी बार है. Words change करके same. He who comes to seek justice should come with clean hands. clean hands. प्लेंटिफ खुद रॉन्ग डूअर नहीं होना चाहिए, प्लेंटिफ खुद फर्स्ट प्लेस पे गलत ना हो. हियर कश्यप इज अ ट्रेसपासर, सॉरी, जरून इज अ ट्रेसपासर. Because Zarun is a trespasser, that's why Kashyap is not liable, as Zarun has trespassed her property and thus he cannot claim damages for his wrong action. Okay, why can't C? Students are asking. Because Kashyap is liable because Zarun could not read the notice affixed on main gate and thus he is not at fault. Where it is written that Zarun, even if Zarun could not read the notice, then also he was a trespasser. Na? What does a trespass means? Trespassing means entering someone's property without that person's permission. Here Zarun is going to give a surprise. वो बिना परमिशन के और बिना किसी लॉफुल जस्टिफिकेशन के एंटर हो रहा है कश्यप की प्रॉपर्टी में. ही इज अ ट्रेसपासर, so he is wrongdoer himself. Because the plaintiff is himself wrongdoer, he cannot sue. So Zarun cannot sue Kashyap. Okay, simple application of principle over the facts, and the right answer can be B only. Question number 5. Vicarious liability. The legal maxim for vicarious liability is qui facit, noted down, per alium facit per se, which means he who does an act through another, he is deemed in law to do it himself. What can be the right answer? Easy question. Just don't miss any word or don't misinterpret any word. Got it? Do not even miss or misinterpret even a single word. You will come to the right answer. Prakash is saying C. Samaira is saying D. What can be the right answer? Guys, the right answer is D. Mrs. Kaushik is not liable because Rinku's act was a crime, not a tort. Easily, a master is liable for the torts committed by his servant. Here, Rinku shot dead a man. It is murder. Murder is a crime, not a tort. Got it? According to the principle, master is liable for torts committed by the servant, not for crimes committed by the servant. Got it? And shooting dead a man is not a tort. Obviously, it's a crime. That's why रिंकू के एक्ट के लिए मिसेस कौशिक लायबल नहीं होंगी. मिसेस कौशिक इज नॉट लायबल फॉर रिंकूज एक्ट बिकॉज इट वॉज अ क्राइम, नॉट अ टॉर्ट. अगर वो किसी को स्लैप करता समायरा, देन हम देखते कि वो कोर्स ऑफ एम्प्लॉयमेंट में स्लैप कर रहा है या नहीं. फॉर इंस्टेंस, अगर मैं फैक्ट्स को चेंज करके ये कहूं कि रिंकू अपने एक दुश्मन को देखता है एंड देखकर वो उसको स्लैप कर देता है, इट इज बैटरी अंडर टॉर्ट लॉ. बट वो अपनी पर्सनल कैपेसिटी में स्लैप कर रहा है. ही स्लैपिंग हिज एनिमी एंड ही स्लैपिंग हिज एनिमी एज रिंकू, नॉट एज मिसेस कौशिक्स सर्वेंट. बट इफ अ स्ट्रेंजर कम्स एंड वो मिसेस कौशिक की कार के साथ कुछ छेड़खानी कर रहा था जिसकी वजह से उसने उसको स्लैप किया, नाउ ही स्लैप्स दैट स्ट्रेंजर इन his course of employment as Mrs. Kaushik's servant, then Mrs. Kaushik would be liable. Remember, vicarious liability के लिए the master is only liable for the tort of servant in course of employment. Course of employment is necessary. Got it? चलिए नेक्स्ट क्वेश्चन पर आते हैं. यस पूनम, ट्रेसपास क्राइम भी होता है एंड टॉर्ट भी हो सकता है, कुछ भी, दोनों में से कुछ भी हो सकता है. ट्रेसपास इज क्राइम एज वेल एज टॉर्ट. इजी प्रिंसिपल. What can be the right answer? Right answer is A. This is genuine mistake of fact by a public officer. or police officer, right? It is a genuine mistake of fact, simply. Nothing is said to be done or believed in good faith, which is done or believed without due care and attention. यहाँ पर कहीं फैक्ट से नहीं पता लग रहा है that he didn't had any due care or attention. Simply, he was investigating the kidnapping case of a child. He charged B of kidnapping and arrested him because a child similar to that was there. So it is a genuine mistake of fact. Question number 7. I hope you have gone through offences against property very deeply in IPC. In IPC, only two types of offences are most important: offences against human body and offences against property. अगर आप offences against property को पढ़ चुके हैं, then you can easily answer it. Superman intentionally throws it into a river ring belonging to him, thereby causing wrongful loss to him. What is the crime that he had committed? Theft, extortion, robbery, or mischief? Okay, Samira is saying D. Let's wait for some more answers, Samira. Then I will reveal the right answer. Okay, Pooja, Shifa, Riddhi, Gayatri, Prakash. Everyone is saying D. The D is the right answer. Mischief. Mischief means causing wrongful loss to someone by degrading the value of their property. यहाँ पर रिंग को नदी में फेंक के उसने wrongful loss किया. थेफ्ट क्यों नहीं है? Because नहीं, the facts didn't say that Superman took out the property out of Ima's possession. एक्सटॉर्शन भी इसलिए नहीं है क्योंकि सुपरमैन ने ईमा को डरा के प्रॉपर्टी की डिलीवरी नहीं ली है. रॉबरी या तो थेफ्ट होता है या फिर एक्सटॉर्शन विद एग्रेवेटेड वर्जन. Aggravated version of theft or extortion in which there is threat of death or grievous hurt or wrongful confinement. Got it? So the right answer is D. The right answer is D. And a robbery committed by 5 or more persons is dacoity. So these four offenses, theft, extortion, robbery and dacoity, are interrelated. Theft is taking out someone's property out of someone's possession. Extortion is also taking out but by his action, मतलब वो खुद डिलीवरी देगा victim. Robbery is either extortion or theft, an aggravated version of extortion or theft, and dacoity is a robbery committed by 5 or more persons. Question number 8. Okay, fundamental rights can be violated only by the state. Article 12 says what can be the right answer? Okay, I've started getting the answers. A student is saying D. Let's wait for some more answers. Thanks a lot, Aryan. Done? Okay, I'm getting mixed answer. Aditya is saying A. B's fundamental right is violated, Aditya. Is it? Khushi is saying C. Okay, I'm getting mixed answers. A, B, C and D. अब चारों आंसर्स मिल चुके हैं. Guys, the right answer is C. B's fundamental right is not violated because act of A is a personal act. First of all, the principle 1 is saying that fundamental rights can be violated only by the state. And Article 12 defines state simply that state includes the government of India, the government of state, and all the authorities under the government. Here, यहाँ पर क्या हुआ, ए ने एक पार्टी ऑर्गेनाइज की अपने बर्थडे पर. ए पुलिस ऑफिसर है, बट जब ए ने बी का माउथ शट किया तब वो अपनी पर्सनल कैपेसिटी में. ही इज नॉट इन कैपेसिटी एज अ पुलिस ऑफिसर, ही इज इन हिज पर्सनल कैपेसिटी. Means he is not a state, first of all, and fundamental rights can be violated only by the state. Since he is not the state, so B cannot claim violation of fundamental rights. अगर आपको अगर ए को बी मार देता है, मर्डर कर देता है, तो आईपीसी सेक्शन 302 में मर्डर का केस चलेगा. आर्टिकल 21 के वॉयलेशन के लिए रिट फाइल नहीं होगी. वाई? बिकॉज ए इज अ प्राइवेट इंडिविजुअल. बट अगर स्टेट के एक्शन से बी की डेथ हो जाती है तो आर्टिकल 32 के अंडर हैबियस कॉर्पस की रिट फाइल होगी. For violation of Article 21, right to life and personal liberty. But if a private individual kills someone, then no writ for violation of Article 21 is filed because a private individual cannot violate fundamental right. Got it? That's why no fundamental right of B is violated. So हम यहां से ऑप्शन नंबर ए को एलिमिनेट कर सकते हैं because it says fundamental right is violated. हम ऑप्शन नंबर ए को कर देते हैं एलिमिनेट. Coming to option number D, B had committed the offense of defamation. Obviously, he had committed defamation, but it's a independent statement. Independent statement. It is true, but not correct. It is true, but principal defamation की बात ही नहीं कर रहा है, इसलिए हम D को भी हटा देते हैं. Option B is saying B's fundamental right is not violated because Article 19(1) is not absolute and comes with reasonable restriction. C, it is also a true statement, but not in accordance to the principle, जो सिर्फ स्टेट की बात कर रहे हैं. So B को भी हटा देते हैं. C can only be the correct answer. Why? Because B's fundamental right is not violated because of A's personal act. On application, so why not D? ममता मैं आंसर दे चुका हूं. D is not the right answer because D is an independent statement. D is talking about defamation. It is true that B ने डिफेमेशन कमिट किया है, बट प्रिंसिपल कहीं डिफेमेशन की बात नहीं कर रहे हैं. करेक्ट आंसर इज वन विच इज द कंक्लूजन आफ्टर एप्लीकेशन ऑफ प्रिंसिपल ऑन द गिवन फैक्ट्स. प्रिंसिपल जब फैक्ट्स पे अप्लाई होंगे तब जो कंक्लूजन आएगा वही करेक्ट आंसर होगा. गॉट इट? दैट्स व्हाई सी इज द राइट आंसर. इंपॉर्टेंट क्वेश्चन सर, इस टाइप के क्वेश्चन की पॉसिबिलिटी है. ऑब्वियसली पूनम, एलेट एंड एमएच-सेट में ऐसे ही क्वेश्चन आते हैं. Question number 9. He who goes to court to seek justice must come with clean hands. What can be the right answer? You need to decide as a judge. Simply apply the principle over the given facts and come to the conclusion. Okay, Samara is saying B. Let's wait for some more answers. Yes, Ashutosh. Defamation is something when a person says untrue thing and a thing that defames that person. In the minds of right-thinking people of the society, a true statement can never be defamatory because truth is a complete defense in defamation. Just like deforestation. Deforestation means degradation of forests. Defamation means degradation of someone's fame. Fame means izzat. Fame से ही बना है word famous. Yes, guys, the right answer is B. Puneet cannot succeed and his termination amounts to breach of a valid contract. Why? Because Puneet is himself the पुनीत इज हिमसेल्फ द रॉन्ग डूअर। पुनीत ने यहां पर क्या लिखा है फैक्ट्स में, दैट पुनीत को कॉन्ट्रैक्ट टर्मिनेट करने का राइट तभी मिलेगा जब वो हाफ अमाउंट पे कर देगा, बट पुनीत ने कोई अमाउंट पे नहीं किया था संतोष को टिल डेट। इट मींस ही डू नॉट हैड द राइट टू टर्मिनेट द कॉन्ट्रैक्ट, so Puneet cannot succeed and his termination amounts to breach of valid contract. I hope you got it. Why B is the right answer? Because he who goes to court of law to seek justice must come with clean hands. So Puneet can only get the right to terminate the contract in case of delay of delivery if Puneet pays half amount in advance, either in cash or kind, but he had not paid any amount. यहां पर लिखा है he had not paid any amount. इट मीन्स अब उसको राइट है ही नहीं टर्मिनेट करने का, इवन देयर इज अ डिले। गॉट इट? दैट्स व्हाई बी इज द राइट आंसर। ऑप्शन सी क्यों करेक्ट नहीं है अब आप समझ गए, क्योंकि उसने हाफ अमाउंट पे ही नहीं किया, जो कि कंडीशन थी। द कंडीशन इज नॉट फुलफिल्ड, कंडीशन नॉट फुलफिल्ड। सर जेएमआई के लिए भी इंपॉर्टेंट है, ऑब्वियसली आ रहे हैं प्रिंसिपल फैक्ट क्वेश्चन, जेएमआई में भी आते हैं। नाउ द लास्ट क्वेश्चन फॉर द डे। Guys, be number one by liking this video. I urge you all to like this session before going. Just like the session. It's the last question for today. Free consent is a prime essential for a valid contract. सर ऑन एन एवरेज कितने कैंडिडेट होते हैं जेएमआई बीएलएलबी के लिए? शिवम, आई कैन नॉट से कि पैंडेमिक सिचुएशन में कितने होंगे, बट इन नॉर्मल सर्कमस्टेंसेस 10,000 students appear for approx 10,000 students appear for JMI law, and the total number of seats are 120, that are 60 regular and 60 self-finance. The right answer for this question is A. Yes guys, it is not a valid contract because Mahesh was a person of unsound mind. Easiest question. A person of unsound mind is not capable to enter into a contract. Yes, so A was the right answer. It was the easiest question. So I hope a lot of you have scored a perfect 10, 100% score. Alright guys, then CLAT 2022, it's a comprehensive course. A new batch had been recently launched. आप इसमें enroll कर सकते हैं by subscribing to Gradeup Super. For any course related query, you can call at this number. And guys, if you are in class 10th right now, planning for CLAT 2023, then it's a foundation course. Enrollment have started for it. You may enroll for it as well and boost your chances of cracking CLAT 2023. Now, who all are your teachers? Who all are your teachers at Gradeup? So all your teachers are NLU alumni who have a hefty experience of 5, 6, 7, 10, even 15 and more than 15 years of teaching. And we have teachers from NLSIU Bangalore, RMNLU Lucknow, RGNUL, NLU Gandhinagar, and most of the topmost national law universities of the nation. So get the benefit of their experience by subscribing to Gradeup Super. Bye bye guys. Have a great day. Sahi prep hai to live set hai.